Now, with 7 nominees, they discover urgent constitutional necessity. Such breathtaking inconsistency exposes an administration driven by political calculation, not constitutional principle. To our nominees, you seek to join an institution whose legitimacy rests on public confidence in your constitutional fidelity. You must become guardians of our fundamental law, not instruments of executive convenience. The Supreme Court's authority derives from moral standing, not political alignment. True judicial independence requires constitutional courage, deciding cases on law and precedent, not political preferences. It means protecting minority rights against majoritarian excesses. It means sometimes disappointing those who appointed you because the Constitution demands nothing less. This committee bears solemn responsibility for ensuring only nominees demonstrating unbending commitment to judicial independence receiving approval. We must probe not merely legal knowledge. To all participants, embrace robust discourse with dignity, ask hard questions, challenge respectfully. Our democratic maturity is measured by our ability to disagree with purpose while maintaining civility. To Ghanaians watching, witness democracy in action, tolerate trading insults. To the media and parliament staff, thank you for enabling this democratic exercise to be undertaken. I conclude by saying that we stand at a constitutional crossroads. These proceedings will either restore judicial confidence or mark the day Ghana's highest court become an executive instrument, not constitutional conscience. The nominees seek sacred constitutional trust. May they prove worthy. May we test that worthiness thoroughly. History will judge whether we defended democracy when it needed us most. Future generations will thank us for courage or condemn us for cowardice. The choice is yours. The time is now. Thank you, Honorable Chairman.
Thank you very much, Chairman. And thank you for indulging me. I did not know the minority leader had a scripted statement as he has done. So I don't have a scripted response, except I picked on a few things that he has said. One, he speaks about the ongoing process relating to the Chief Justice, Justice Gertrude Tokono. I first and foremost think that this is not in relation to Justice Tokono. I think it is inappropriate, but let me just indicate that there is nothing procedurally questionable in terms of the processes that Justice Tokono is being taken through, because the Constitution is clear in terms of what the process is, and that process has been followed diligently, and efforts to question that process in the Supreme Court has not been successful. And so I find it inappropriate that before a committee of this nature, the minority leader will be questioning the process. And on the issue of accusation that this government is engaged in double standards, I think that is also not appropriate. The nominees are before you for you to vet their suitability, and to say that this government is engaged in double standards is totally inappropriate. I was on the appointments committee when the 2 nominees were rejected. And let me indicate clearly that my side of the House advocated for the rejection on the basis that at that time, the anticipated retirement of some judges, which would have created the vacancy, hadn't taken place. And there was no need in anticipation to be appointing replacements. And we also argued, and I do not shy away from that argument, that the then president had had the opportunity to nominate so many members onto the Supreme Court. And even if some judges were retiring, he should give the opportunity for an incoming president, given that we're so close to elections, to also have an opportunity to also nominate people to the Supreme Court. It wasn't clear who will be the incoming president. It could have been an NPP incoming president. It could have also been an NDC incoming government. Of double standards, in my opinion, is inappropriate. And I think that we should not use the nomination of these Supreme Court judges as a the vetting of the nominees as a platform to be engaged in partisan politics. I think that basically that will be my response for now, and I welcome the nominees, and as indicated, we will be vetting them according to the standards set by our Constitution, and I hope that this doesn't become another partisan bickering exercise. Thank you.
Honourable members, our revered nominee and the guests, you are all welcome.
Thank you.
Honourable members, following the appointment or nomination by His Excellency, the President of the Republic of Ghana, it was read in Parliament and referred to the Appointment Committee, following which we have scheduled today to perform our responsibility by way of vetting the nominees, reporting to Parliament, and then getting the approval or disapproval. For that reason, first on the list is Justice Senyo Dzamefe. I am aware he is the longest serving judge in this country. He's a Court of Appeal judge. Without wasting much time, we'll proceed to swear him in. So, Clerk of the Committee, may you proceed to administer the oath.
I, Justice Senyo Dzamefe,
do in the name of the Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
So help me God.
Honourable members, it's for some time now we didn't do vetting. So the public may want to know us again by way of self-introduction. My name is Bernard Ahiafo, First Deputy Speaker of Ghana's Parliament and Chairman of the Appointment Committee.
I am Alexander Kwamena Afenyo-Markin, Member of Parliament for Efutu. I lead the Mighty Minority Caucus in Parliament, and I am the ranking member of this important committee of Parliament.
And I am Patricia Apieje, a Member of Parliament for representing the good people of Asukwa, the Deputy Minority Leader, and a member of this committee. Thank you.
Thank you, Chairman. Patrick Boma, MP, Okankwe Central, a member of the committee. Thank you.
Thank you, Mr. Chairman. I'm Tony Meir, Member of Parliament for Dotobri. and the Vice Chairman for Committee on Judiciary.
Thank you, Mr. Chairman. I am Nana Ejeyi Bafo Ewua, MP for Menchia South, and a member of the Constitution and Legal Affairs Committee.
Thank you, Mr. Chairman. Good morning. My name is Hassan Tampuli, Member of Parliament for the good and virtuous people of Gushegu in the Northern Region, and Deputy Ranking to the Committee on Constitutional and Legal Affairs. Thank you, Mr. Chairman.
Yes, you have the floor.
Thank you, Mr. Chairman.
Thank you. My name is, I am the ranking on judiciary and a subject matter representative on this particular committee. Thank you.
Thank you, Mr. Chair. My name is Eli Klim Akurugu, representing the good people of Dome Kwabinya. I'm a member of the committee. Thank you.
My name is Al Hassan Umar, MP for Zabzugu in the Northern Region, and a member of the Committee on Appointment.
Ladi Ayayamba is my name, MP for Pusiga, and a member of this committee.
Honorable Chair, my name is Jerry Ahmed Shaib, representing the good people of Wejagbawe and the second minority whip.
Chairman, thank you very much. Honorable nominee, welcome. Chairman, my name is Roxanne Nelson Dapamokbo, MP for the good people of Southern in the Volta region, majority chief whip, a member of the committee. Thank you.
My name is Mahama Ayariga, Member of Parliament for Boku Central and Majority Leader and Leader of Government Business. I'm the one that the standing order says I can sit and ask questions.
Thank you very much, honorable members. May I proceed and humbly ask the nominee to tell us about himself.
Thank you, Mr. Chairman. Once again, good morning, Mr. Chairman and honorable members of the committee. I am Senyo Dzamefe. I come from Agogwenlume, a village near Ho. Mr. Chairman, after my basic education, I entered the University of Ghana in 1979 to read law. I graduated with the LLB in 1982 and proceeded to the law school. Graduated in 1984 and was called to the bar. I was posted to the Attorney General. In 1988, I joined the public tribunals and was the regional chairman of the Tema Regional Tribunal, as well as WA Regional Tribunal. In 1994, we were integrated into the main system, the Judicial Service. And in 1996, I was posted to the Circuit Tribunal in Koforidua. In the year 2000, I was appointed a High Court judge and posted to 2nd D. In the year 2002, I was transferred from 2nd D to Swedru High Court. I was in Swedru High Court to 2008 and posted to the Fast Track Court 4, Accra. In 2010, I was appointed Appeal Court judge. And then
My Lord, just be brief.
All right. We have an association, the Association of Magistrates and Judges. I was the vice president when I was in the High Court and then became the president when I was in the Court of Appeal. Then, Mr. Chairman, I represented all my benches on the Judicial Council, lower court, high court, and the Court of Appeal bench. And then I was a member of the Rules Committee for 2 years, 2 terms. I was the chairman of the Disciplinary Committee of the Judiciary. I was a member of the Appointments Committee. I was a member of the CMJA and a member of the Planning Committee that held the International Conference in Ghana. On the national level, Mr. Chairman, I chaired the Brazil Commission set up by His Excellency the President, John Dramani Mahama, to investigate into the Black Stars Brazil World Cup campaign. For my hobby law, I do at GIMPA voluntary lectures. Then I introduced the bench faculty interaction when I was the president of our association. We did for GIMPA and Legon. I chair the moot court in Legon. I go to the gym, I do K-Fit, I walk. And to top it all, I'm an ardent soccer fan. And Mr. Chairman, I never walk alone. Thank you.
He says he doesn't walk alone. So you should understand.
Thank you very much. Very well.
He doesn't walk alone. So
very well, very well. I will proceed to give the floor to Honorable Akurugu to start asking questions.
Thank you, Mr. Chair. Good morning. And then welcome.
Morning.
Yes. What is your view on the doctrine of separation of powers in Ghana? Thank you.
The executive, legislature, and the judiciary. Thank you.
Thank you very much. Wishing you all the best.
Thank you.
Thank you.
Yes, Honorable, you have the floor.
Your listeners. Thank you, Mr. Chairman. Congratulations to your nominee.
Thank you.
Yeah, Mr. Chairman, my question to the nominee is, what innovations would you suggest to improve justice delivery in Ghana? Innovations would you suggest to improve justice delivery in Ghana?
Thank you, Mr. Chairman. Anybody who wants to maximize productivity must first think of the human resource. That is a mistake a lot of people make. First, think of those who will give you the product. So, Mr. Chairman, the first is to motivate the staff. Motivate the staff. We need more courts. When we have more courts, the job is spread thin and it goes faster. Number 3, after the courts, what next? You need the tools, the working tools. Because if you have the courts, we need the tools, technological tools now. Time of long handwriting is past. So we have to go to AI tools like voice recording and transcriptions, so that by the end of the day, just as the court finishes sitting, the records are ready. Then, Mr. Chairman, we also need to go virtual courts so that travel the way. So when you have virtual court, last but definitely not least, months, civil 6 months, there must be timeline. Then the parties as well as the court knows that we are within certain time period to finish cases. Thank you.
Thank you, Mr. Chairman. I'm done.
Thank you very much.
Thank you, Mr. Chairman.
You are entitled to ask one question.
Mr. Chairman, I'm entitled to ask only. Good morning, Honorable Nominee.
Morning, sir.
I want us to do some little exercise in the Constitution relative to the opening provision under Chapter 11, Article 125 to be precise. Mr. Chairman, if you permit me, I will just read Article 1251. Justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. End quote. Honorable nominee, in this Constitution, to ensure that the judiciary is indeed independent. If so, why? If you can give me 2 or 3 provisions.
Thank you, Mr. Chairman. When we have 3 aspects, the judicial aspect, the financial and administrative aspects of the judiciary. When it comes to judiciary, yes, we are independent. Administrative, yes, we are independent. Financial, I don't think we are, because you people, you give us money. When the budget comes to you, you are the people who think about it and allocate what you think we need. So basically, those 2 aspects, we are independent, but when it comes to financial, we are not. Thank you.
Mr. Chairman, I have a follow-up. And the follow-up is that, can you reference any provisions in addition to this one that guarantees and fortifies the judicial independence?
Yes, the Constitution says that when cases come to you, as much as possible, you have to be independent in what you do. You don't have to listen to anybody when you are judging your cases. So as much as that, we are independent. We don't have any interferences, no. You work on that is what you have to do. Our allegiance is to the Constitution and not to any human being or any other authority. Thank you.
Yes, I'll proceed to give the floor to Honorable Awua Bafo. Please, you have the floor. Equally, 1 question.
Chairman. Mr. Chairman, I want to confirm a report that captures the nominee, and then I will ask my substantive question if you agree. Sir, on the 30th of September 2021, Major Online reported a statement made by you whilst President of the Association of Judges and Magistrates, to ask my substantive question.
Honourable Member, do you have a copy of the report? You have to take a cue from your leader. Your leader will always bring a copy, and then we show the nominee what you are referring to.
Sure, my lady, Mr. Chairman, do you mind if
electronic copy?
It's an electronic copy.
Yeah.
Okay. Okay. It states as follows. It is sad that judges in Ghana will have to fight every year for their legitimate allowances to be paid. It is sad that the leadership of the association has to personally trek to the Ministry of Finance, Controller and Accountant General's Department. We have to fall on friends at the seat of government to push for such allowances to be paid, he said on Wednesday. Please, do you confirm making the statement?
Yes, Mr. Chairman.
Okay. Now, in view of this, how is judicial independence compromised? Does this affect judicial independence?
No, Mr. Chairman. This is just simply about lobbying. Lobbying, which everybody does if you want something. Thank you.
Now, presidency also comes to lobby you. A friend of yours who you lobbied for your allowances to be paid also comes to lobby you in respect of a case before you. What will you do about it?
1 good turn deserves another.
1 good turn, they say, deserves another. What will you do about it?
Mr. Chairman, as judges, we base our decisions on the evidence and the facts, not on friendship. So if I are falling on somebody to press something, not for me, but for the association, I was talking for the association, and that person appears before any court, not necessarily my court, the decision will be based on the facts and the evidence, not because...
On the issue of whether or not you are independent, you stated clearly that regarding financials, it looks as if you are not. Very
yes,
well.
Mr. Chairman.
Thank you, Mr. Chairman. Congratulations, nominee. My question is, would you recommend suppression of investigative journalism to protect the dignity of the judiciary?
Yes, Honorable Nominee.
Can I get the question again, please?
Very well. Can you repeat the question?
Okay, very well. My question is, would you recommend suppression of investigative journalism to protect the dignity of the judiciary? As expose, in fact, it's been reported by TV3 News. This is online. You are reported to have said that the expose, in quotes, tainted the dignity and value of the judiciary. It is also reported that you said, quote, that the expose should have been blocked. So that is the reason for my question.
Mr. Chairman, I don't remember the first quote. No, those are not my words. And then saying it could have been blocked. No, I don't think, I'm not very sure. Why would I recommend suppression? No, I wouldn't. One is fair, fine. But I don't remember the first statement you made, because those are not my words.
Thank you very much. Yes, Honourable Member.
Thank you, Mr. Chairman.
Any
I have a follow-up
further
question. How would you balance protecting the reputation of...
Yes, Honourable Nominee.
We can't gag the press. So far as they do a good job and they don't misinform or disinform, we don't have any authority to gag them. The only guidelines are make sure what your reportage is the truth. The press can come to report our cases or come to do anything with the judiciary. We are not sacrosanct. They can come and do that. We don't have the power to stop them, but just make sure that what you are reporting or your reportage is the truth. Ask. Don't report on perceptions. Please, Mr. Chairman, don't forget the judiciary is different from the judicial service. But a lot of people mix these things up. Things happening in the judicial service are attributed to the judiciary. We are two different arms, but working together. Thank you.
Yes, any further question? Very well. Thank you.
You are entitled to 3 questions. It's different from the constitutional legal. No, you are a bona fide member of the committee.
Very well. Then I have other questions for you, my lord.
Honourable members, regarding Anthony Imie, I never said you are entitled to 1 question.
I am very grateful.
That is why I am asking you, do you have any further questions? And you said, no, you don't have a further question. So if you have a further question,
I have 2 more.
Just proceed to ask.
Thank you very much, Mr. Chairman. Now, nominee, Yao Opong, who is Justice of the Court of Appeal and an authority on constitutional law, has suggested that it was unconstitutional when the Dzamefe Commission released a white paper prior to the release of the full report covering, it's reported in My Joy Online. Prior to the release of a full paper, yes, a full paper on the 2015 World Cup inquiry. Now my question is, paper prior to the release of a full report is a violation of the 1992 Constitution.
Thank you, Mr. Chairman. I had the commission. We wrote our report and made recommendations and presented the recommendations to government. That was all we did. We never issued any paper, sir. Thank you.
Thank you very much.
Thank you. Now, a follow-up question.
A follow-up question on that.
Justify the violation of a constitutional provision.
Well, permit me to treat this as a full question, not a follow-up. So, Honorable Nominee, you have the floor.
Mr. Chairman, anything that violates the Constitution is illegal. Whatever it is, once it violates or flouts the Constitution, it's illegal. Thank you.
Yes, you are done. Thank you very much. I would proceed to give the floor to Honorable Bid Azidin. Honorable Bid Sidin. I want Tanzuma. You have the floor.
Thank you very much, Mr. Chairman. I'm happy that you have corrected yourself in the pronunciation of my name. He has taken me to be a Frafra man. I'm a Dagat man. We don't start our names with A. Leader, why are you surprised? Anyway.
Please, your question.
My Lord, congratulations for the nomination. I think it's long overdue. You have been on the bench since 2010, 2000, and you have stayed there as a High Court judge until you were promoted to, elevated to a Court of Appeal judge. You have been in this business long enough. Fortunately, you are not one of the judges that is coming from outside the judiciary. Yes, I'm just building something. So, my Lord, in your judgments and doing interpretation, what are some of the rules of the interpretation that you have applied as a judge? Thank you.
Thank you, Mr. Chairman.
Honorable Nominee.
Thank you, Mr. Chairman. Interpretation. The basic rule, the first rule is the literal meaning of the words. The literal meaning of the words. I wouldn't go into details. You read the words as they are. Then number two, if the words create an absurdity, then you go to the next step, which is the golden rule. You ask yourself, what does the law seek to achieve? Then you interpret it to achieve the purpose. Then the third is, what does the law seek to prevent? That is the mischief rule. Then you interpret it as such. Then you go further. We have one we call the Jusdem generis, things of the same kind. So you know how to do there. And then there is one that tells you how you use words around a word to interpret that word. So these are some of the rules of interpretation we follow. Thank you.
Thank you very much. Yes, Honorable Bid Zidin, Ranking Member, Judiciary.
Thank you very much.
You have a further question?
I have no follow-up question, but I want to go to my second question.
Very well. Please do.
I just want to say that His Lordship's answer represents, I believe, a most excellent education on the rules of interpretation. Maybe TikTok will just take a bit of it and spread so that law students will benefit from this.
Thank you.
What innovation would you bring on board to improve justice delivery in this country?
Mr. Chairman, let me finish.
Has been asked and answered. The question has been asked and answered by another person. The previous questioner has asked a similar question, and my Lord has provided answers to the question.
Very well.
Wait, Honorable Bid. You know, the question you asked which chairman says that has been already asked. The language, the same words, phrases, are you all coming from the same source of tutorials?
Nobody, don't answer that. Nobody has been giving tutorial in these matters. So please proceed to ask if you have another question.
Mr. Chairman, indeed, there's nothing wrong with that.
Further question?
Yes. Mr. Chairman, I only want to congratulate my Lord again, because fortunately for me, I appeared before him whilst he was High Court judge at Swedro, and I saw that he was a very fair-minded judge.
Thank you. Thank you very much.
Yes, Honorable John Darko.
All right, thank you very much, Mr. Chairman. Coming from the interpretation aspect, Mr. Nominee, if you read Article 66(2), it says that a person shall not be elected to hold office as President of Ghana for more than 2 terms. Do you think that this provision is subject to interpretation?
Mr. Chairman,
Honorable Nominee.
The honorable member quoted from the Constitution, and that's what the Constitution says, so I can't have anything against what is in the Constitution. Thank you.
Yes, a follow-up question on the interpretation of Article 66.
Mr. Nominee, so if somebody says that a president answer to that person.
Honorable Chairman.
Thank you very much. I'll proceed to give the floor to Honorable Alhaji Omar. You have the floor.
Thank you, Mr. Chairman, Mr. Speaker. My Lordship, congratulations.
Thank you.
I want to go into your rulings and opinions in your previous judgment. And it has to do with your position of the law regarding property owned by couples in divorce or death. What is your position? Thank you.
Thank you, Mr. Chairman. Our Constitution guarantees that every citizen can have property on his own or her own, and then in association with others. So I'll first go to on death. When a spouse dies, PNGC law 111 comes in to take care of those who are alive. Then when it comes to a will, if a spouse dies intestate, that's he hasn't written a will, then like I said earlier, PNDC law 111 comes in. If there's a will, we go according to the will. But then, if no reasonable allocations are made to the surviving spouse, the court will interfere, will go into the will and give something reasonable to the surviving spouse. Then what
do you mean intervention or interfere? Do you mean the court would intervene? Sorry.
When it comes to wills, we are not supposed to. Is it the word interfere or intervention?
What I'm asking is, do you mean the court intervening or you mean interfere? You said the court will interfere. I'm asking whether you mean intervene.
I will still use the word interfere because when it comes to wills, we are not supposed to. We interpret as much as the person making it wants it to. And so, Mr. Chairman, to continue, when it comes to divorce, if the property is jointly acquired, both parties have reasonable access to that property. And that's how the court looks at it. But then, a new decision now goes to say that if we must look at all cases on their merits. Recently, Ajay says that, well, it's not automatic. You look at the circumstances. For example, if the property is jointly acquired, fine. But if it's not, if it's not jointly acquired, maybe I took a loan for it as in Ajay, the court will not regard it as jointly acquired property. So the sharing will be different. But on the whole, when there's divorce, the court will make sure that a reasonable or equitable size of the property is given to the divorced spouse. Thank you.
Thank you. Any further question? Thank you very much. Honorable Patrick Yaboma, the floor is now yours.
My Lord, my Lord, you've handled a lot of commercial cases. Some of us practiced before you. And sometimes business interests do conflict with constitutional rights and other issues within our Constitution. For example, when foreign investment rules to always, or sometimes, let me use for want of a better word, sometimes tend in favor of what some Ghanaians refer to as and local or domestic rules do clash. How do you manage that thin line to ensure that there is confidence from the investor community on our judiciary?
Thank you, Mr. Chairman. Our judgments are always based on the evidence before us and the law. First of all, the ground norm, the Constitution, whatever it says is the law. Two, if you can't get it from there, you go to case law or statute, and you go according to what they say. As a judge, you have the discretion to interpret, but you don't go outside the remits of the law. Mr. Chairman, that's it.
Is any further question? Yes, if you have a follow-up, please do.
My Lord, most of the agreements that we ratify in Parliament do have some arbitration provisions in there, but you realize that some of these investors do rush straight to the foreign courts or tribunals without exhausting local remedies, and many times the AGs have to go to London or some of the international tribunals to have some of these decisions reversed before it comes back to you. How would you advise on some of these things as a judge?
Thank you, Mr. Chairman. When unilaterals and multilateral companies are involved, you look at the contract they have signed. If there's an arbitration clause in it, they have to explore that first before coming to court. So as a judge, you look at their, refer them back to it before they come to you. Thank you.
That's my second question. Very well. My Lord, in the past, you've called for the law school. You've called the law school to teach subjects like cybersecurity, intellectual property. Why is this so important, and how can we modernize our legal education without losing focus on fundamental legal principles? I know it's part of some of the issues that we've spoken about, having some of these specialized courses being taught at the law school?
Mr. Chairman, law is dynamic, and the life of the law is not left behind if you don't follow the trend. So now cyber security and things are now issues of the moment, and it's just prudent that students coming out as lawyers are taught these things. So that is the reason. I don't remember if I got the question well that I suggested. I don't remember that, but even if I did, that is the reason behind it. We must be abreast with times, otherwise we are left behind. Thank you.
My Lord, this is my last question. Since you never walk alone, on your CV, you were chairman of the Koforidua Circuit Tribunal from 1996 to 2000. And Ghanaians recall the work of public tribunals. Because once you are invited there means it means Wahala don't come. A lot, and I know it's part of our constitution, public tribunals. Would you advocate for the setting up of public tribunals again to speed up or assist with the justice delivery program? Thank you.
Thank you, Mr. Chairman. I like the way you put it. That's exactly what I would do. But unfortunately, it's a wrong perception. People are more relaxed when they appear before the tribunals because, you know, the panel is 3. 2 ordinary people and the judge, who is a lawyer. They are more...
But you say that is your last question. Very well.
My Lord is enjoying the question. So relax, Chairman. My Lord, don't you think Justice Senyo Dzamefe sitting with 2 ordinary Ghanaians on a public tribunal will bully them with his law, Chairman, and direct them as to how to take certain decisions, especially when they are not legal practitioners or professionals in that vein? Thank you.
Thank you, Mr. Chairman. It's unfortunate we think... Say, Mr. Chairman, I said once somewhere that law is 20%, wisdom is 80%. Don't underrate every case. They know, and you can't bully them. Thank you.
Thank you. I will proceed to give the floor to Honorable Jerry Ahmed Shaib.
Thank you very much, Honorable Chair. I appreciate the opportunity. My Lord, congratulations and you're welcome. Honorable Chair, if I have your permission, I just want to refer to the Constitution, Article 1461, that states that misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. My question is about 3 acts or omissions that for you would constitute stated misbehavior, and 3 acts or omissions that you think would not constitute stated misbehavior. Thank you.
Mr. Chairman, if
yes, my Lord, we realize that there is a pending matter on that issue before the courts. So you are sitting in your capacity as a nominee being vetted. You are not sitting here in a capacity as a Supreme Court judge. So I am inclined to humbly overrule the question.
Thank you, Mr. Chairman.
Chairman, with respect, the nominee hasn't made a specific reference to a particular case for, and the questioner hasn't made reference to a specific case. I believe that if I understood you right, you are more or less relying on a sub judice principle to rule the question out of order. I humbly submit that to the extent that the nominee is here to express views on the Constitution and public policy matters, you allow him to answer. If we now box ourselves into this situation, then I'm afraid we may not be doing justice to the responsibility imposed on us by the Constitution this morning. He has not referred to a particular matter. And like I argued recently on the floor, the sub judice rule cannot be applied in absolute terms, that there is a matter related somewhere, so Parliament cannot move. He referred to the Constitution and said, what is your view? Give us 3 instances. That is not related to whatever matter you are referring to. In any event, you haven't shared with us the matter that you think, if the question is answered, it will create a problem for same. So I respectfully submit that you permit it.
Honorable members, we all know the matter, even if not expressly stated. He is a Supreme Court nominee. In aspect end up at the Supreme Court, you may be called upon to preside over it. So, honorable members, it is not proper that we solicit the opinion of a Supreme Court nominee before us on the question being asked. With all due respect, the question is overruled. I will give the floor to the member to ask another question.
Thank you very much, Honorable Chair. Honorable Chair, before asking the question, I just want to make reference to this. It's, with all due deference to you, it has nothing whatsoever for me to do with a pending matter that has to do with the Chief Justice, which you are making reference. If you look at even the paraphrase, it goes on to say that removal of justices of superior courts and chairmen of regional tribunal. So, respectfully, it has nothing whatsoever to do with the stance you are taking now. Because I have asked that, what would constitute? Is going in as misbehavior.
Honorable member, you know the rules. After the ruling of the chairman or the speaker, we don't argue that. Please ask another question.
Very well. Just for purposes of record. My Lord, respectfully, would you consider superior court judges to have all, when they are supposed to have, you know, as government appointees, they are supposed to file every indication of properties they have. And they do what we call the declaration of assets. Consider for judges of the Supreme Court or judges as a whole to also have, as in, file their declaration of assets? And if yes, respectfully, why? And if no, why not? Thank you.
Mr. Chairman. Honorable nominee, please proceed to answer the question.
Mr. Chairman, as the Honorable said, if that is the law, that all, why not? They have to declare their assets. Thank you.
So is it the case that you have filed your assets declaration?
Yes, Mr. Chairman.
Very well. Honorable Chair, whether we are considering technological impact on constitutional requirements. So it has to do with when acting for the president who is absent and vice president, but not when the vice president is acting alone. In an era of instant global communication, does this distinction remain constitutionally necessary? That should the absence from the Republic be redefined? And when the vice president is also not in town, we have the speaker. And we are asking, so against this technological advancement.
So, Honorable Jerry, what exactly is your question?
President, Vice President, the Speaker, what would be your position? Do we have the Chief Justice acting?
Yes, Honorable Nominee.
From my long experience on the bench and from my own wisdom, I scarcely give views and opinions on issues because the view or opinion I'll give carries so much weight. I'm a judge. Who knows whether tomorrow this same issue will come before me? And then I'm expected to go by what I said. Meanwhile, the facts may not be on all fours. So as much as possible, I don't give views and opinions on things, on topical issues like this. Thank you, sir.
Thank you. Any other question?
Just a follow-up. My Lord, is it to say that when there are issues of general knowledge and you are being requested to make a statement on, you will decline doing so just because whenever you make such, it carries weight, so it would mean something else?
No, Mr. Chairman. Currently, there's a situation on hand. Currently, there is somebody acting. So whatever I may say...
Was specific, sorry. I made reference to technological advancement.
Honorable member, you are entitled to a follow-up question. And you have
yes,
asked
I'm
the
just trying to
follow-up
make,
question.
because...
You have asked the follow-up question. Yes, Minority Leader.
Chairman, I want to help to situate the question correctly. My Lord, the gravamen of his question was to the effect that there's clarity on, in the absence of the president, vice president acts. In the absence of the vice president, the speaker acts. And in fact, that has received judicial blessing, where the speaker would even have to take the presidential oath. What he's asking is that in the absence of all these three, so for instance, recently, Mr. President was out of the jurisdiction on an ECOWAS assignment. Madam Vice President, Her Excellency, was on medical leave. Mr. Speaker was also on an official assignment outside of the jurisdiction where there was this constitutional lacuna. What he wants to know is whether in the situation like what I've mentioned, the Chief Justice would have to act or take the presidential oath as acting president. That's the point he wanted to put across.
Mr. Chairman,
the Chief Justice or acting Chief Justice or the head of the judiciary.
This is peculiar.
Yeah.
Like you rightly said, if the president is not there, the vice will take the oath. If it's not there, then the speaker, and then it goes down to the Chief Justice. But unfortunately, during that period, there wasn't a substantive Chief Justice, but we have an acting Chief Justice. I don't think the law says that the acting Chief Justice should take an oath. Thank you.
So in that instance, the Chief Justice will have to take the presidential oath as acting president, correct?
Yes.
All right.
Yes, your last question.
Thank you very much, Honorable Chair. My Lord, respectfully, government recently has engaged in a deportation policy of foreigners who have been found to be illegally mining. And my question to you is that, does this violate Article 17 of the equality before the law? And can citizenship status justify different legal treatment for identical criminal conduct?
Mr. Chairman, as to what the law says. So if the law says that a foreigner has committed a crime and after conviction and sentence, they are to be deported, why not? Thank you.
Yes, a follow-up. But in these instances, there's no conviction and sentencing. But the fact that they have been arrested.
Thank you, Mr. Chairman. Say why they were deported. I think it was an executive or decision, so I cannot say why. Thank you.
Thank you very much.
The leader of government business.
The nominee. You've been around for a while. I remember of our Supreme Court, how many judges we should have. A political, legal issue. And even this morning, when you sat there, you were greeted. Ask, as a member of parliament representing a constituency at the furthest end of the country, that is Boku, is entitled to litigate his case up to the Supreme Court by way of right to appeal up to the Supreme Court, depending on where he started. If I'm a citizen of Boku and I start my matter either in Boku or at the High Court in Bolga, I must always to justice at the Supreme Court. Have you thought about the need for a northern bench? Just as you now have a Court of Appeal in Kumasi, and I think you had even started in Cape Coast. Have you thought about the need for a northern bench of the Supreme Court so that the people of the North do not always have to travel to Accra when they seek justice in the Supreme Court?
Thank you, Mr. Chairman, and the High Courts. So I don't see anything wrong if there's a branch there.
So, to really be fair, maybe we should consider having a branch up north of the same a policy like that, even though you are not in a position to take that decision, but you are not opposed to a policy like that. That's what I gather from your response. As at now, what is the size in terms of the number of the judges in the Supreme Court? Do you recall? I won't hold you to it, but do you recall how many we have now? If you take out the 7 nominees that we have before us.
13, I guess, 13.
You have 13. In 2024, the Chief Justice wrote a letter to the President recommending that the average size of the court should be 20. The letter was made public, I think, by Asase Radio, so I'm sure a lot of people had the opportunity to see the letter. Asase Radio made the letter public. I have the report here, the media report, in which Asase Radio has shared details of the letter requesting the appointment of the 5 judges. And then the letter included a detailed analysis justifying the need for these appointments. So beyond my argument about a northern bench of the court so that people in the north can have access to the US, I don't know if you saw the letter or at least read the media reportage and discussion of the letter. Because I want to take you through the details. I don't know if you saw the letter or you read the media reports. Just let me know that so that I can know what information to put out when doing the analysis.
Thank you, Mr. Chairman. I haven't cited the letter, but I heard a bit of it on social media.
Well, yeah, the Chief Justice argued, and I don't know if you agree with this argument. I'll just three arguments, and then I would end it there. One Chief Justice says that, they have to write opinions, they have to hold conferences, and if you have less than 20 judges, it definitely affects the administration of justice at the level of the Supreme Court. Do you agree with that?
Mr. Chairman, I haven't cited the letter you are referring to, and I don't know the reasons given, but from what I heard from you, delays and that the judges are overburdened because of the case limit onto the number of Supreme Court judges. It's not capped. I keep saying that the law is always evolving. Maybe there's a reason. So far as the Constitution doesn't cap the number of judges, I am for it. Thank you.
The second argument that the Chief Justice makes is that Chief Justice in the letter indicated that in actual fact, in the US, they have 50 Supreme Courts in the states, plus the one federal Supreme Court. And so you can't compare the Ghanaian situation where we have one Supreme Court versus the US that has 50 Supreme Courts at the federal state, at the state level, joining the federal Supreme Court. Do you subscribe to that argument of the Chief Justice?
Yes, Mr. Chairman. See, in the states, every state has its Supreme Court. That is the state Supreme Courts. And then
there are 50 of them.
Yes, and then the Central Federal Court. And even on that, it's only constitutional and federal issues that go to the Federal Supreme Court. And then on top of that, they have the discretion to choose. Unlike here, they have the discretion to say that it's only on 6 cases we sit in the year. So they are not overburdened like we have here. So if the argument of in that letter you says that due to delays and the caseload, number of judges be increased, fine, I support it. But I guess that the flexibility is there for the evolving nature of the system, which there must be justification for every additional judge. Thank you.
Yeah, the CJ, in making a case for a minimum of 20 judges at the Supreme Court, indicated, for instance, and gave statistics, that in 2018, 2019, in the US, the federal Supreme Court, the US Supreme Court, the cases filed numbered 6,442. 6,442. But that year, the cases that were argued, out of the 6,442, the cases that were argued were 73. Only. And indeed, the cases that 6,442, and then you could only, they only dispose of 73, because they, like you said, they have a right to choose what cases to hear and what cases not to hear. But our Supreme Court, disposes, on the average, disposes of about 400 cases in a year. Judges really do well.
Yes, Mr. Chairman, I will say that they do very well. Our Supreme Court here has 3 main jurisdictions. Original, it's loaded, and is virtually becoming a daily court. So I buy the argument that they are overloaded, and therefore there is a need to increase the numbers.
So in general, you agree with the argument that indeed we need to have more Supreme Court judges so that we can have cases expedited and people's right to have access to the Supreme Court vindicated.
Mr. Chairman, yes, I agree.
The last one which is generally about the rule of law, you know that investor confidence is also moved by the extent to which a country has the rule of law entrenched. Economic performance is also based on levels of investments in your country. So there is a direct relationship between the rule of law, having access to justice, expedited justice, and economic development. There's a direct relationship, since rule of law is one key indicator that encourages foreign investments into the country. So do you say that if we have more judges and cases are held expeditious?
Mr. Chairman, that is true, because if within a short period your issues are resolved, why not? You have confidence in the system. But if it takes too much time, then you lose trust in the system. So I will always agree with you that the faster the cases go, the better for the investor community. And then there's trust in the system. And therefore, if the small numbers are going to delay cases, why not? Why don't you increase the numbers so that but that doesn't open the floodgates that you keep. Thank you.
But is it not inevitable that we're going to have more numbers because we are creating districts and each district is demanding a court, and we are creating new regions and each region is demanding, a court, high court, and we are, graduating many lawyers into the system, and many more people are going to have access to justice, and the lawyers are going to be appealing. Is it not inevitable that the caseload is definitely going to increase? In which case, the right to appeal and therefore the number of cases that will end in the Supreme Court will also increase whether you like it or not.
Thank you, Mr. Chairman. Courts, so that accessibility to justice is very easy. It's good if we have plenty courts and then the cases are spread thin and cases move faster. So I support your idea. The more courts we have, the better for us, and dispose of very early. Cases delayed 10, 20 years, 15 years is not the best. If we have plenty courts and then within few months the cases are disposed of, why not? I am for it, Mr. Chairman. Thank you.
I'm asking this question basically because ultimately it is a burden, and as a nominee, you will have to make a case to the taxpayer why he should pay for your services as part of the considerations that as a committee we will be making. So you do agree that citizens ultimately will benefit if we have an adequately sized number of judges at the Supreme Court?
Mr. Chairman, nothing good in life comes without a cost. Yes, we have to weigh the pros and cons. Yes, I agree that more money will be spent on the judges and the courts, but then the benefit, quick disposal of cases, we weigh all and we go for the more courts to make the citizens and the investor community happy and have confidence and trust.
I will then give the floor to Honorable Hajia Ladi Ayamba.
Thank you, Chairman. Let me first of all say congratulations, well done.
Thank you.
I looked through your CV and I realized that you are a basket of a lot of knowledge and good things in your own industry.
Thank you.
We have observed that in our justice system and justice delivery, many a times, a lot of your work is delayed. A lot of your work is delayed. Someone could be in court for even 10 years. Not even only, not in your place, the superior, but even the lower courts. So there is this perception that Justice delayed is justice denied, to be done to stop or at least to reduce the delayance in justice delivery. Thank you.
Thank you, Mr. Chairman. The tools we use, AI. One of our main constraints is the recording process, writing longhand, and then the processes by themselves. A lot of people who don't know this always say cases delay unnecessarily. Yes, sometimes it's tools. If we can go AI, said that recordings are done swiftly, so that by the end of the day, whatever everybody says in court is recorded by the machine, and at the end of the day, it's transcribed, and you can just sign. It makes it faster. And then number two, a lot of adjournments. That one depends on the courts. A lot of lawyers come, I'm sick, I'm that, sending letters and blah, blah. We have to curtail those things as well to make sure that cases go on. And then I said something earlier that there should be time limits. I think the rules of court should set time limits, that no criminal case should go beyond 3 months. No civil case should go beyond a certain period of time. Then we all know we are constrained to finish within that time. These are the justice. And then more courts. If we have more courts, then the workload is lessened. One court wouldn't have plenty cases if there are other courts around. So, Madam, these are some of the things we have to do to be able to deliver justice in good time. In good time. Thank you.
Go to our prisons. Most of them are choked. And it's as a matter of judgments, either delayed or wrong judgments or whatsoever. My main worry about those in these prisons are that some of them are not persons whom we should even send to prison, or we should even delay their cases. Someone goes to steal a bunch of plantain. An underage goes to steal, so you go and dump them, and sometimes even they are not segregated. The hardened, the non-hardened, all of them are together. What will you suggest to ensure that I will call these people, these little pilfering and what have you, they don't find themselves languishing, sometimes even years, sometimes for...
Your question.
My question is, what will you suggest to be done to those people so that we don't get them going into detention and wasting time?
Thank you, Mr. Chairman. Madam, you said we collect them and go and dump them. We don't do that. We try them, and if they are found guilty, they are convicted and sentenced.
Please, I'm not going and come, and the place is choked. When the police cells are full, they remand. You send them to the prisons where maybe they are not.
Thank you, Madam. We as judges interpret the law, the laws you make. If you change the laws, we interpret it accordingly. The prosecutors come to ask for remand because they have not finished with investigations. Madam, you can't ask the people to go home. You remand, but there's nothing the judges can do, please. Thank you. So we are waiting for you to change the laws. Then, for example, the penal system.
Very well. I'll proceed to give the floor to the Deputy Ranking, Honorable Patricia Apiaje.
Right, thank you very much, Mr. Chair. Honorable Nominee, going by your CV, I'd like to ask a question, because if I look at the time that you were born and the time that you entered secondary school, I'd like to find out, at what age did you enter the secondary school?
A little less than 12.
Specifically?
I went to the secondary school in 1970.
Yeah. So we presume that you entered at the age of 11.
11 plus some months, please.
Thank you very much. I found it very interesting. So I found it very interesting.
Luckily, my father was a head teacher, so I.
Right, thank you. Honorable nominee, how many judges do we have at the Supreme Court currently, practicing judges, and how many are women? I'm talking about current one. How many are women?
Current Justice Mensa Bonso. And then the CJ Justice Tokono, 3.
And how many in total, please?
13.
13. Thank you very much. Honorable nominee, I'll proceed to bring to your attention that last year, 2024, exactly in June, the Gender Equality Act, Act 1121, was passed. One of the questions I want to put to you at this point in time is that this act mandates gender parity in public appointments. And Article 144 requires merit-based judicial selection. If these provisions conflict, for example, if achieving gender parity requires appointing a less qualified candidate, which takes constitutional precedence and why? Which of the two? I've given you indication of the constitutional and then the legal aspect of it. Thank you.
Mr. Chairman, as much as possible, you should send the best to the Supreme Court, or you should appoint the best wherever. You don't use the gender equality thing to appoint somebody who you think is not qualified, but because of gender. So I will always go for the quality. If it means gender, if the person is not suitable or qualified for the job, you appoint the person to satisfy gender equality or gender parity. Thank you.
Thank you very much. So, to follow up, I would like to find out, what would you suggest should be the best approach in ensuring the achievement of the gender parity as is?
If a lady qualifies, or yes, if a lady qualifies for a position, why not? Gender parity does not necessarily mean that you appoint women to satisfy the numbers. No. If the woman is qualified equally as the man, then when you are appointing for the job to satisfy that parity. Thank you.
So, Chairman, I think I need clarity on this because I asked a specific question. What would you recommend should be the approach to achieve that? Thank you.
Madam Chairman, if you pass me through and I get to the Supreme Court, then maybe when it comes, I can then recommend, but as at now, I cannot recommend anything. Thank you.
Any further question?
Yes. Thank you very much. Honorable nominee, one of the issues are constitutional interpretational issues that we have faced. In the 1992 Constitution, it guarantees equality before the law and prohibits discrimination, as you rightly said. Given that approximately about 35% of Ghanaian couples of equal protection, with the current legal framework that denies cohabitants the same rights as married, protecting cohabitants from legal vulnerability.
Mr. Chairman, as at now, what the Constitution says is what we have to do, because whatever we say beyond the Constitution is noise. And no matter how many noises you make, what the Constitution says is what overrides. Thank you.
Thank you very much. There's also another aspect of this issue of cohabitation. And teen relationships are highly vulnerable. They are highly vulnerable upon relationship dissolution. How should the court balance respect for traditional marriage institutions with a constitutional mandate to protect vulnerable population, particularly women, who may have contributed significantly to households but lack the legal recourse? Thank you.
So, Mr. Chairman, what is the question, please?
The question is that we've observed that women, a large number of women are in cohabitation relationships. And these women are highly vulnerable. They face violence, and most of the time they even contribute to the well-being of that relationship. But they are not recognized in law. And therefore, it is important that we also look at their vulnerability and protect them.
What's his view on that?
What is your view on
Thank you, Mr. Chairman. We can't give hypothetical solutions now. Maybe if I get to the Supreme Court and a case like that comes to the Supreme Court, then we'll look at it on its own merits and then maybe evolve some case law to take care of such situations, please. Thank you.
Ranking member has a follow-up question on that. But let me bring it to the fore that we are yet to pass the cohabitation law.
My Lord, the exchange we're having is deal to the hypothesis in this discourse and express a view, because once it becomes difficult, then I'm sure you followed previous discourse. Actually, when you get there and a case comes before you, you will now, juxtapose your own view against the reality that comes before you. On top of that, I would proceed with the follow-up from my respected colleague. The children out of wedlock are recognized. Do you think that the law is being fair to those women?
Honorable members, before allowing my Lord to answer the question, we must also be careful the kind of question that we ask. Judges, by their nature, deals with the facts and the law.
That's a fact.
They don't deal with hypotheses. And my Lord has made it very clear to the facts. You may, however, answer this question.
Mr. Chairman, thank you. As much as possible, the law is there for everybody. The fact that the lady is cohabiting and there's no law covering cohabitation doesn't mean it should be thrown away. We'll look at the case on its own merits and make sure a reasonable or a reasonable portion of the property is given to the person or taken care of.
Minority Leader, any further question?
Yes, I do. I know the justice, the nominee, is a very experienced man. And I would like to find out from you, what has been the most significant judgment or legal opinion you've delivered in your career thus far, and why does it stand out for you? I just want you to share that with us. Thank you.
Yes, Honorable Nominee.
There are a lot, but if I remember very one, and Chief, when it comes to adverse possession, I really define what adverse possession is and whether when there's a case before you and a chief court, and it's very often quoted. And then another one is the Mozamadisco Cristo Church case in Sweden. I remember when I was in Sweden, the Akaboha. That is one other case. And then this case from, I think, Sefri, yes, where at the end of my case, a chief was destooled and an Anglican bishop took over as the paramount chief and took up the cassock. They are interesting cases. Thank you.
I wanted you to share with us why you feel the ones that you've mentioned, really stand out. Maybe you must have a special...
No, Mr. Chairman, I took my time to explain the law, to expound the law, and it's so many times quoted by the lower courts. The other cases I wrote, there's other judgments in the Court of Appeal as well that are often quoted.
Right. Thank you. I'd like to know, normally when we are vetting nominees, when we are vetting them, we are presented with some of the interesting rulings that you've made and judgments. May I know if you did present some of these, or you have with you some of these judgments which you have passed?
Honorable members, as a matter of fact, the nominees are here to answer questions from you. Questions were not given to the nominees in anticipation, as a result of which the nominee would have to bring copies of those excellent judgments that he has delivered there and then. So I will plead. Please ask another question.
Chairman, with respect, for anyone who has followed proceedings regarding justices of the Supreme Court, the records will bear us out that we've always requested for some judgment that they have written. With due respect to Chair, I do not think that asking such a question is really out of order, because my Lord is known, his industry at the bench. So if he's asking whether you have any of your judgment or any ruling with you, yes, obviously, Chairman, yes, allow. I mean, definitely appearing before us, it should be reasonably contemplated that a thing like that may be asked. Not that as a requirement, but obviously, since we want to know his views on the law, like the cases he mentioned, it would have been helpful if he had the judgment readily with us. Maybe, he could say, he could furnish us some of his judgment later. But it's something that we've been demanding. This committee, check the records, Mr. Chair. So I do not think that it's out of place. But I think it's even an opportunity for us to say this to the nominee. There are 6 of you who are left, that at least in coming, they should carry along some of the very groundbreaking judgments that have defined their career. It's always okay to carry them along. It's good for learning. That's all I would say.
Honourable members, if the plea, do you have the judgment here without knowing whether the judgment will be requested or not, I believe that is not fair to the nominee. That's the reason for which I am overruling the question.
Honorable Chair, not to challenge you, but I'm just giving clarity to the question that I asked, because these are very interesting judgments that have been passed. I have copies of such judgments. So if you can bring it later, I think we will appreciate it. Before the, yeah. Thank you.
Allow that if the question is a suggestion to the nominee whether he can make copies of those judgments available. But I still insist if the question...
Yes, thank you very much. Please, I will request that the nominee makes it available later before the decision is taken. Thank you. For the interest of everybody in the judiciary, the U.S. provides life tenure. Which of these two systems better serve judicial independence? And if I may ask, and why? And if I may ask, would extending Ghana's retirement age to 75 require some constitutional amendment? And would you support such a change? Thank you.
Thank you, Mr. Chairman. If I got the question right, whether it should be, if I got the question right, what, Madam, are you asking whether we should extend the age to 75?
Yes.
All right, thank you.
Thank you.
Before I answer this one, we were given requirements as to what to bring, That's why we're not asked to bring judgments. That is why it's like we didn't bring any. I didn't bring any, but I'll sort that out. Mr. Chairman, I will not agree with sending the retirement age of the Supreme Court or Appeal Court judges to 75. No. The retirement age as of now is 70. Madam, Superior Court judges retire on their salaries. I guess formally, you need to be advanced in age to get the experience and the exposure so that when you give judgments, it's respected, it's a solid judgment because you're adding personal experience to the knowledge, the legal knowledge you have. But, Madam, with all respect, of late, technology has made it such that what you need 60, 70 years to know, technology can make it available 25. I want judges to retire very healthy, and then we can use them for other purposes like assessors. They can help the judiciary or the service in other forms like assessors to filter our cases. So I think we maintain it at the 70 as of now. That is my opinion.
Thank you very much, and I wish you the best. Thank you.
It's now the turn of Honorable Minority Leader.
You're not asking?
Honorable Roxanne Nelson, Ache Dafamoko.
Wezo. The old students of HEPS, they've sent me a message to let you know that they are extremely proud of you.
Thank you. I thank them.
And they wish you all the best.
Thank you.
Yet, my Lord, I want to ask a couple of questions in terms of policy and some forward-looking matters. The Constitution in Article 142, 143, and 144, 3, 4, and 5 thereabouts, as part of our judiciary, but there's been some hesitation. And I'm being compelled to litigate it for a declaration that the omission amounts to. How important would the addition of the regional tribunals to our current judiciary, the current structure of the judiciary, High Court up to the Supreme Court, serve the needs of the judiciary?
Thank you, Mr. Chairman. Yes. I am always for the tribunals, the setting up of the tribunals, because one, we say we have too many cases pending and the cases delay. If we set up more courts, definitely it's going to help alleviate that. High Court judge, it's just that two ordinary people who are not lawyers are to help him, assist him. So I don't see, it's just the nomenclature, the naming, but the jobs done are virtually the same. And then more criminal cases will go to the tribunals because they wouldn't do civil. So it gives more chance to the mainstream court to have more time for civil cases. So I am always for the tribunal, manned by the people from whom justice emanates. So I am always for the tribunals. And the Constitution says it has to be done, so it has to be done. Thank you.
Thank you very much. My Lord, I have been waging two wars. One in respect of the welfare of some judges, and one in respect of the welfare of law students, so to speak. So in respect of the judges, we have at the magisterial level, we have the career magistrates and what the judiciary has come to describe as professional magistrates, trained lawyers who have been elevated onto the bench from the magisterial level, and a program that produces magistrates with some structure to be attained as chief magistrates when you go through the ranks. What I have observed, having become a member of parliament, is that there are disparities in their conditions of service. Disparity in the sense that the career magistrates do not have official accommodation. They do not have official vehicles to assist them to work. Yet the professional magistrates, they have official accommodation and they have official vehicles. And my Lord, within the Labor Act, they do equal work. And the law is very clear. This House passed it that equal work must attract equal pay. So as a matter of policy, will you, the career magistrates, to that of the professional magistrates as district court judges?
Thank you, Mr. Chairman. I remember very well when I was on the council last year, this issue cropped up to make them, to bring the parity. They do the same job. So you are right to say that they deserve equal remuneration and the perks that go with it. So I support you. They deserve that. I think the committee is working on it. I don't know whether it's out yet, but it's being taken care of. They deserve what you are saying. Thank you.
Great. My Lord, my other war that I wage, and which I think the Judicial Council will have a role to play, is in respect of the legal reforms that we want in legal education. Some faculties have been accredited to run the academic programs, but they have not been accredited to run professional programs. But there's been a bloat in the number of the faculties that produce men that obtain the academic qualification necessary for you to train as a professional lawyer. So our monolithic law school is inundated with the numbers. And I've seen hesitation on the part of the Judicial Council, which has very large membership on the General Legal Council, to advise that the law school, there should be, by way of license, so to speak, the faculties be granted the license to also train professionally and then read upon. But we need the faculties to train professionally as well as our law school as it is. When you get onto the Supreme Bench, will you consider by way of policy? Because every Supreme Court judge has the potential of acting as a Chief Justice at one time. Will you, as by way of policy, give this firm support that the law school, the faculties be permitted to train their products professionally, so one...
I know Honorable Member is a very strong advocate for this. We have to weigh two things: quality as against quantity. I think there is, or there must be, some reason for which the law school at Makola is built near the court. Because I keep saying the court is the lab where you go to do your practicals. Yes, I agree with you that other professional courses, professions like accountants and others train elsewhere, whatever you want to train, and write one exam. I know that's what you are advocating for, that the faculties should be allowed. But the question is whether we can have control over the way they are trained. We don't just necessarily say because you pass the exam, fine, you are qualified. There must be some training sessions, some training procedures. It's a dicey issue whether all faculties should be allowed to train their lawyers and then they write one exam and they all qualify. If we have the facilities to regulate and make sure that they go by the...
But by way of assistance, will you be of a different opinion if the curricula is redesigned to capture the essence, the matters that...
Exactly what I'm saying. If that is done, and the faculties must be supervised to make sure that they attain that level of standard we need, fine, why not? Then they write one exam, and then when you pass, you become a lawyer. So I'm for it. But then we must watch the quality. Thank you.
I thank you for your answers. Let me also add that in your previous answers, I've listened to your concerns regarding the proposal to have time limitations for trials. The Rules of Court Committee hasn't done well in this matter. So let me inform you that to be called the Fair Trial Act. Yes. Now, my Lord, let me say this.
Not done well should be expunged from our records.
Chairman, thank you very much. You've been on the bench since 1988, actually, for the records. So that's about 37 years as a judge.
Yes, Mr. Chairman.
And yet we are now considering for the Supreme Court. Congratulations.
Thank you.
I wish you all the best on the Supreme Bench.
Thank you, sir.
Thank you very much.
Thank you, Honorable Roxanne Nelson. It's now the turn of Honorable Minority Leader and the ranking member of the committee.
As you read in your opening statement, this committee is fortified by a letter from the President dated the 20th of May 2025, which letter states as follows, that on 29th of April 2025, I submitted my nominations by letter to the Judicial Council for appointment to the Supreme Court. The chairperson, Acting Chief Justice Bafo Boni, on behalf of the Council for appointment to the Supreme Court, under Article 1442 of the Constitution of Ghana, 1992. I consulted with the Council of State by submitting the above names and their curricula vitae to the Council of State. Next sentence. On 7th May 2025, the Council of State notified me by a letter and a report indicating their suitability for appointment. Honorable nominee, from the President's letter, it is obvious to me that Council of State did its work within 36 hours or less. May I know from you whether you were contacted by the Council of State as part of their work before recommending you? May I know from you?
Mr. Chairman, I was not called by the Council of State to meet them, no.
Now, would you disagree with the suggestion regarding the speed with which the Council of State communicated back to the presidency? 36 hours. Council of State consultation. Do you find it rich?
Mr. Chairman, that one is beyond my control.
Very well. Now, as part of our own due diligence as a committee, we peruse your CV. And here, just to avoid surprises, I want to ask you whether you have your CV with you. You have it right with you?
Yes, Mr. Chairman.
In soft or hard copy?
Hard copy.
Very well. So we'll have a little exercise on your own CV.
Okay.
Good. So as part of the due diligence that this committee did, it attempted to validate some of the information by relying on other institutions of state. On the issue of educational background, item 1, Norwegian School of Management, Oslo, Norway. To validate this, could not confirm this for us. Are you able to provide us with the certificates and the transcript of this qualification you've so provided yourself?
Yes, I'll do that. I
Very
can.
well.
Then the state agency you relied on didn't do a good job.
Yes, we relied on the NIB. They wrote to us formally.
I schooled there, and I can provide you the necessary things you want.
The NIB wrote to us formally. Now, so you agree that sometimes our state agencies make mistakes or they fail us. You agree with me on the basis of this? Since, was it a scholarship from the Judicial Service, full-time program you took off correspondence or part-time?
Mr. Chairman, this is a full-time course. I was given scholarship by the Norwegian government. In 94, 95, when we were integrated into the mainstream judicial service, we were not working. So I took the opportunity, took permission from the service, and went to pursue this course and came back after a year.
So the scholarship was not routed through the judicial service?
No, it was the Norwegian government scholarship.
Did you apply for it?
Yes, I did.
Very well. Now, you've answered the question and not 14. I'll give you the time to reconcile that. We'll come back.
What if yes, okay, if you give him the time, I can refer to our diary and see the correct numbers.
Yeah, sure. That's what I'm saying. I'll give you time to reconcile that. Now, still on your CV, you went to the training college.
Yes, Mr.
After
Chairman.
your O-level.
Yes, Mr. Chairman.
Then just after the training college, you went to the university from the records and the dates you provided.
Yes, Mr. Chairman.
So,
I taught for a year before going to the university. Yes, before going to the university. After I finished training college, I taught for a year. Within that year, I went to the university.
So you taught for a year, but you've not indicated the school you taught.
But that was in Pando in 1978.
Very well. Because, so when did you finish the training college? Which you say 75 to 78. The academic calendar, do you readily remember which month of the year you finished, you completed your program at Judicial?
I think we finished in June, July 78, and I was posted to Pando November, December when I went to the university. Okay. So you can check from the Ghana Education Service.
No, my lord, if you say I can check from Ghana Education, that's I find no. I'm
not you personally.
Yes,
I mean, we can cross check.
No, I'm dealing with your CV. I'm dealing with your CV. So that's why I said, do you have it with you? A little bit of patience would help. Okay, so it's your own record. It is not anything hypothetical. So now, according to you, 78, you were done with training college around July. You were posted, and then you taught up to December, correct? So that ends 78. Then you have here LLB, University of Ghana, Accra, Ghana. LLB, Hans. Then you say 79 to 82. So I want to know from you, the 79, which month, if you recall, did you start your first academic semester?
Mr. Chairman, I finished training college in 78, was posted to Pando Gabriele Middle School. I was a teacher there and entered the university the following year, 79. We started, I think, in September 79. I didn't enter the university in 78. I entered in 79, sir.
My lord, I didn't say that you entered the university in 78. I haven't said that. You said the records would bear me out. That's why I repeated it just for clarity.
No,
so you
okay.
Relax with training college in July of 78. Your earlier answer was that you were posted to a school in Pando and you taught in that school up to December of 78 and entered university, please, entered university in 79. Please clarify.
Thank you, Mr. Chairman. I taught for a year in Pando, that's 70, and entered the university in 79. I went to Jaskan Training College in 1975. We were the first batch of the 3-year post-sex. Finished in 78, and I was posted to Pando Gabi LA Middle School, where I taught for 1 academic year. And in 79 September, I went to the university. So if Mr. Chairman, the CV says 79 to 82 to the university.
Yeah, so it means that your earlier answer that you taught up to December.
I don't remember. Did I say that?
Yes.
Oh, then I'm sorry.
That's why I came back.
Then I'm sorry.
Yes, that's why I came back for you to reconcile.
No.
Okay, very well. So, my lord, you also said, you stated on your CV, you said you went to training college after your O-level. Now, I am aware of Cape Coast University those days. They would admit A-level, SS, professional, or mature students. Did you enter the university mature student or with a combination of your post-secondary certificate, that's your training college certificate?
Mr. Chairman, I entered with 3 A-levels, not post-sec degree certificate. I wrote the A-levels whilst in the training college. We have adult education courses there, and I had 3 papers before entering the university. I wrote the A-levels in the training college, and that's what I used to enter the university.
Which subject did you do for your A-level?
Economics, religion, and geography, and then general paper.
My lord, you said you only speak English and Ewe, correct?
Fluently, correct.
But you stayed in Aguna Sudro for more than 6 years, and my lord did not make an attempt. Is that the case?
At least I can speak some little, like yours, Abazi. I can say that one.
My lord, but Aguna, they speak Aguna. Aguna Sudro, they speak Abazi.
Yes. Well, I wrote English and Ewe because those ones I can speak fluently.
So, but the tree,
I understand you, but let's keep it there.
On Article 126. Let's go there. Please, you have your constitution with you. My lord, you there? Very well. In your earlier submissions, you indicated that Superior Court justices retire on their salary.
Not fully, because you need to do a number of years.
Okay, so if you say you need to do a number of years, let's bring clarity to it. Superior Court justices are in 3 categories: Supreme Court, Court of Appeal, and the High Court. Correct?
Yes, Mr. Chairman.
Now, which of these categories? 4, Regional Tribunal stroke High Court. Regional Tribunal Chairman stroke High Court. It's the same thing. 3. I don't want to talk about Regional Tribunal. I'm not interested in the populist revolution thing. I'm not interested in tribunal where you use your aura, abuse people's rights. I'm not interested. I'm dealing with the
members, order.
Chairman,
the reference is to Article 126.
Very well, let's
the
proceed.
Judiciary shall consist of the Superior Court of
Chairman, I'm able to read.
Comprising the Supreme Court, the Court of Appeal, the High Court, and Regional Tribunal. So you cannot say you are not interested in the Regional Tribunal when you are making reference to Article 126.
Chairman, thus far, we've had some peace. Restrain your chief whip. We kept quiet for him to ask all his questions. Anyway. So, which of the categories is the number of years of service applicable to?
Mr. Chairman, some people join the service from after civil servants who have retired. For example, there are 60 where they were working before joining us.
My Lord, I'm not stopping you. I'm not stopping you. Please. We may stay longer depending on your approach. We may have a very short session if we deal directly with the issue. And that's what I would prefer, the latter approach. So please bear with me. We know the Constitution defines 3 categories: Supreme Court, Court of Appeal, High Court / Regional Tribunal chairs. And in your answer, you qualified the earlier position you are taking, that Superior Court justices retire on their salaries. You qualified it by saying that, yes, but it depends on the number of years of service. I want to know from you, of the 3, High Court, Supreme Court, Court of Appeal, which of them is this number of years applicable to enable them retire on their salaries?
Mr. Chairman.
Or is applicable to all?
It's applicable to all.
Oh, I see. So, for instance, if a person is nominated to Supreme Court and he serves only 4 years and retires, is it the case that he would not qualify to retire on his salary? Is that the case?
Mr. Chairman, it depends on the number of years you've done the civil and the public service before joining.
So let's be specific. The person,
if you sorry, okay.
The person came from the bar. He's a private practitioner who was nominated, a professor at a private practitioner from the private sector, a businessman, someone who has worked with corporate Ghana and not in public service or civil service. Please, I'm done. Yeah.
Mr. Chairman, what I know and what I'm saying is that if you are from the public service and you join the judiciary, if you do 10 years as a judicial officer, you retire on your salary. But if you join from outside and you don't do the 10, if you do 20 years before coming, will be added, and then you qualify. It's a constitutional provision.
Please, which? Okay, they are saying Article 155 from here, if you may read that aloud.
Mr. Chairman, it states that notwithstanding the provision of this chapter, a justice of the Superior Court of Judicature who has attained the age of 60 years or above shall, on retiring, in addition to any gratuity payable to him, be paid a pension equal to the salary payable for the time being to a justice of the Superior Court from which he retired, where A, he has served for 10 continuous years or more as a justice of the Superior Court of Judicature, or he has served for 20 years or more in the public service. For 20 years or more in the public service, at least 5 continuous years of which were as a justice of the Superior Court of Judicature. And upon retirement under the clause, he shall not hold any.
Honorable nominee, may I know from you whether, in view of the provisions in Article 126, having regard to your earlier position that to enable the court function properly, human resource is critical. That is, judges and officers of staff, judicial service staff must be paid well. Would you recommend a constitutional amendment which will incorporate the lower court justices, i.e., district magistrates, circuit court judges, to come under this provision of retiring on their salaries. Would you recommend that?
Mr. Chairman, this depends on the kitty. I wouldn't recommend that. I think this is an incentive for you to work hard and enter the superior court. I think it's a way of rewarding you for your hard work. So I wouldn't recommend that everybody falls into that category, sir.
Now, Superior Court justices come under Article 71 office holders, correct?
Yes, Mr. Chairman.
So, High Court judges every 4 years, correct?
When you say every 4 years they enjoy the emolument, I don't understand you. Judges, our salaries are not reviewed every year. It's done once in 4 years. So what is paid back is the difference. That is what is paid every 4 years.
Let's go to Article 71. Lord, let's go to Article 71.
Charlie, just hold it.
Yeah, my Lord, if you may read 71 for us.
Okay. All of 71.
Rightly
Right.
so.
The determination of certain emoluments, 71. The salaries and allowances payable and the facilities and privileges available to A, Speaker and Deputy Speakers and Members of Parliament, B, the Chief Justice and the other Justices of the Superior Court of Judicature, 3, C, the Auditor General, the Chairman of the, and Deputy Commissioner of the EC, the Commissioner for Human Rights and Administrative Justice and his deputies, and the District Assembly's Common Fund Administrator, D, the Chairman, Vice Chairman, and other members of D1, National Council for Higher Education, so described. 2, the Public Service Commission. 3, National Media Commission. 4, Lands Commission. 5, National Commission for Civic Education. Being expenditure charged on the consolidated fund shall be determined by the President on the recommendations of a committee of not more than 5 persons appointed by the President, acting in accordance with the advice of the Council of State. 2, the salaries and allowances payable and the facilities available to the President, the Vice President, the Chairman, and other members of the Council of State, Ministers of State, Deputy Ministers, being expenditure charged on the consolidated fund, shall be determined by Parliament on the recommendations of the committee referred to in Clause 1 of this article. For the purposes of this article, and except as otherwise provided in this Constitution, salaries includes allowances, facilities, and privileges, and retiring benefits or awards. Thank you.
So, back to your earlier position, you said that every 4 years, when this committee meets and makes recommendation, because your salaries are not done yearly, they make recommendations and you are paid salary arrears, correct?
Yes, Mr. Chairman.
Which is known on the streets as emolument.
Yes, Mr. Chairman.
So, you disagree with any suggestion to the effect that Article 71 is only there to benefit the political class from the reading you have just made? From what you have just
Mr.
read.
Chairman, what the Constitution says is what it is, not the interpretation people put on it. This is not, it doesn't mention a political class here. It mentioned the categories of people who should enjoy this Article 71 emoluments.
Yes, so I'm saying that from what you have just read, those to benefit from Article 71 is not limited to the elected political class. That's the point I want to make from what you've just read.
Yes, I think you are right.
Correct. Now, my Lord, I want us to go back to an earlier position taken by my respected learned colleague, the leader of the House, Honorable Ayarga. He relied heavily on the CJ, Justice Araba Isaba Tokono's recommendation at the Supreme Court. And you seem to have agreed with him, correct?
But the reasons given by the honorable man, I said yes.
Very well.
Because I haven't seen the article she wrote.
Very well. Yes, of course, he quoted from the copiously from the letter. Now, you would agree with me that this proposal led to a public outcry. But now, we are adding 7 more to the same court. Would you, as a beneficiary of this, would you say that that criticism was unfounded?
Mr. Chairman, if I got it right, it's the Judicial Council that raised the first criticism. The Judicial Council, if I got it right, that the names didn't originate from them. That is all I know. So it was not like I am a beneficiary of, like the word you use, beneficiary. No. I was nominated by the President of the Republic to become a Supreme Court judge. I don't know whether it's based on an article or...
The argument was to the effect that the court, a colleague of yours, who had been vetted, I think my lady, is it Benasco, wasn't it? Yes, I have here. Your colleague, Justice Sophia Rosetta Oduokua Benasco Esa, who had been nominated, vetted, and a report submitted to the plenary. As a result of this rather loud disagreement, Parliament could not even take the report. And
please continue.
the loud disagreements, including threats on the floor, the laying of the report will generate chaos, eventually prevented the laying of the report. I want to know from you that in view of the argument that even these two adding to the Supreme Court would amount to packing, would you now disagree with that opinion that this 7 being added, of which you are a beneficiary, worsens the matter?
Well, before allowing the chairman of the committee to answer the question, I would ask that the issue of a threat to the laying of the report be expunged from the question. Please proceed to give an answer.
Chairman, I speak of the record, though I will respect your ruling, but I will pull the Hansard. Fortunately, my respected colleague who used the word, there will be chaos. Hansard captured him. If you are ruling it out now, I don't mind to take that one out, but I will bring the Hansard to just, we are not done yet, so I would bring it, so at least once there's a record.
Honourable members, I believe and support the principle that matters that happen on the floor of Parliament is a closed book. Please proceed to give your answer.
Thank you, Mr. Chairman. I have just been nominated to the Supreme Court. I don't know anything as to whether I benefited from anything or I don't know, Mr. Chairman. I can't exactly tell what happened on the floor of Parliament. I don't know. That is what I can say, Mr. Chairman.
My Honourable Nominee, did you become aware of the general apprehension in the public space regarding the 2 nominees as same amounting to the packing of the Supreme Court? Did you become aware of the general apprehension in the public domain at the time?
No, Mr. Chairman.
Okay, fine. Would you disagree with any suggestion to the effect that this 7 nominations from the president at a go amount to the packing of the Supreme Court? Would you disagree with that suggestion?
I think you answered this question, said no. So why is the question being repeated? So, Honourable
Honourable Nominee, the Supreme Court of Ghana has not been capped by any constitutional imperative, correct?
Yes, sir. Yes, there's no cap.
You would therefore agree that circumstances may result in having a certain number on the bench, correct?
Yes, sir.
So, in view of that, you would disagree to any suggestion that seeks to condemn or criticize for the number to go up to a certain point. You would disagree?
Mr. Chairman, it depends on the justification. It depends on the exigency and the justification accorded to the nominations. Thank you.
You will agree with me that the current 7 nominations have not been accompanied with any verifiable justification or exigencies. You would agree with me?
Mr. Chairman, I'm not the appointing authority, so I wouldn't know why. So it's difficult for me to answer why.
Man, I want to register a protest on record. I know that you are not sharing your power. I would plead through you to my respected colleague seated immediately to your right. The interjections, though not on record, those interjections are becoming too loud and too many. And we've started well. The man seated there, I've appeared before him, and he knows me very well, and I know him very well. We are discharging a constitutional duty. If it were to be on personal level, I say, my Lord Dzamefe, please, I've passed you. We are doing a constitutional exercise, and we have political views on certain matters. You've had your turn. This thing that we do, then it get out of hand, the public misconstrue.
All other members are accordingly restrained. The floor is given to the minority leader and the ranking member of the committee. So
you must add or sign him to be say that.
No, this attempt to run me under the bus, I won't accept it. Were you not interjecting me? Were you not? Did anybody protest?
please, you have the floor.
Please proceed.
Honorable nominee, may we do some exercise on constitutional evolution and textual fidelity. In your view, when should the Supreme Court adapt constitutional interpretation to changing circumstances, whereas at the same time, a view regarding adhering strictly to original text has to be complied with? And maybe let me hear you on that, then I can do a follow-up.
Mr. Chairman, the Supreme Court, as the apex court, is a policy court which we cannot deny. That is why they are decisions based on the evolving nature of the law and situations. So the Supreme Court, saying that something has to be done, are at liberty to depart from their previous decisions. That's why they are not bound, Mr. Chairman.
Can you provide an instance where you would favor evolution and one where you would insist on textual fidelity? I know I have a textualist right by me, but who am I to even say he's seated to my left or right? I have
Please
a textualist with me.
Proceed to ask your question. Nobody seated by you has the power to interpret the Constitution. Ask your question.
So may you provide an instance where you would insist on textual fidelity?
Mr. Chairman, if a decision is given per incuriam or a wrong law has been applied or from it, Mr. Chairman.
Honorable nominee, let's talk about judicial ethics and independence. Would you be able to give us 3 specific measures you would implement or you suggest to be implemented to maintain judicial ethics whilst preserving independence?
By the ethics of our job as judges, 1, you go strictly by what is before you, that is the evidence before you, and the facts. If I got the question right, you base your decisions on the evidence and the facts before you. You are not to depart from this. And then if it's I don't know whether it's the social aspect you are asking, your comportment, your rapport with lawyers who appear before you, it's there. You must know how you relate to parties who appear before you, the language you use in court, comportment, as I said earlier, your punctuality. You must just give out your mind. You don't care whether it's coming from A or B. These are some of the ethics we go by. And then you must know where you go and where you don't go, where you are seen and where you are not seen. Thank you.
So in view of that, how would you then balance the question of transparency with the need to avoid inappropriate commentary on legal issues?
You just have to know how to balance it. It's a thin line. If you heard me earlier, I said comments and opinions passed by judges carry a lot of weight because you don't know when a case will come before you. So you have to be very sparing as to comments you pass because, 1, a case may come before you and the facts may be different, not on all fours. You have to depart from what you said. Even some people can even petition your recusal from the case because of a comment you once passed. So you have to be very careful as to the comments you pass as a judge because it carries weight.
Now, you are aware of the ECOWAS courts. You become aware of the ECOWAS courts, my lord.
Yes, Mr. Chairman.
And you've equally become aware of other judge-made laws in other jurisdictions that sometimes lawyers appearing before you may rely on for persuasive purposes, etc.
Yes, Mr. Chairman.
Now, in your view, should foreign constitutional precedents influence Ghana's constitutional interpretation?
Mr. Chairman,
Sorry. If I may add, just to make it composite, when, if ever, should the Supreme Court cite decisions from, say, South Africa, United States, United Kingdom, or even ECOWAS court decisions? I may take it again if you want to take down the question. Are you okay? Okay, proceed.
Mr. Chairman, any decision from outside nation, we belong to a community of nations, sorry, we are not an island. You can learn best practices from other areas and import into the law, but that should not override your own laws, because whatever comes from outside is persuasive. Mr. Chairman.
Now, on the issue of democratic theory and constitutional purpose, I want to know from you, constitutional term limits serve primarily to prevent individual power concentration or to ensure democratic competition, in your view?
Mr. Chairman,
My question is, in your view, does constitutional term limits serve primarily to prevent individual power concentration, or it is there as a constitutional imperative to ensure democratic competition?
Can you give me some examples, please?
Yes. The example is that, for instance, in Ghana, there's a constitutional term limit that, okay, for the presidency, your term, 4 years, you can go again. And you earlier answered it when you said somebody was trying to, that my colleague John Daku was suggesting to you that, does that mean consecutive terms? And you said the Constitution says 2 terms and that's it. Of course, we've had Professor Kwesi Prempeh, the chair of the Constitutional Review Committee, being very clear that 2 terms means 2 terms. Now, with that background in mind, what I'm asking you to primarily prevent individual power concentration, or is there to ensure democratic competition?
What the Constitution says is the law. Whatever you say beyond the Constitution is noise. And no matter the many noises you make, what the law says, Mr. Chairman, it says 2 terms. And whenever the Constitution gives a term limit, you have to follow it, Mr. Chairman. Unless it's amended or repealed, you don't have a choice. There's no other interpretation you can give to it than what it is, Mr. Chairman.
My Lord, you have earlier expressed a view on interpretation methodology, and you ran us through the various issues to consider. And I think I heard Honorable Ayariga commending the view expressed and invited the students to pay attention to that. Having given that view, and I would want to ask you this. Ghana, which sometimes can have politically sensitive cases, should the Supreme Court err towards restricting or expanding executive power when text permits?
Mr. Chairman, I've said this several times with all respect. That what the Constitution says is what should be done. I don't know what more to add, sir. If the Constitution says 2 terms, I don't see how a different interpretation can be put to it. Mr. Chairman, I don't know what... That's what I think, sir.
My Lord, your colleagues who came before you, especially during Kufuor's era, had cause to give a certain interpretation to the Constitution. And just for our purpose, I remember that in looking at the law, they suggested, they made a strong point in their judgment to the effect that once the president is out of the jurisdiction, there must be someone in the jurisdiction to act, and the person must take the judicial oath. Now, it's been long. This ruling or judgment has been in our books for so long a time. It's like what we previously, as lawyers, were adhering to, that when an injunction application is filed, though it has not been determined, once you've been served, you must not do anything to disturb it. And we're going on with this for a long time, till recently in the cohabitation 3-2 decision, my Lord Kulendi writing the majority opinion, said no, there must be express order from the court. That is now the new law without any ambiguity, and says that constitutional bodies must be allowed to do their work and all. The nation has heard you, the court, on this, and we would abide. Now, having given you this sufficient background as to precedent, may I know from you whether, in view of technological impact, on repeated occasions, in view of technological impact, having regard to when acting in the absence of the president and the vice president.
Mr. Chairman, if the law says he needs to take an oath, he has to take it. If it doesn't say so, then he doesn't take it. Thank you.
But does the law say so? The Constitution says so, that he must take an oath when acting as president. Take the presidential oath. Does the Constitution say so?
Yes.
Lord may guide us with the particular exact provision, please.
If you see, I think it's article.
Provide that later. But you can furnish us with that later. But my Lord, my question directly related to this is that in an era of instant global communication, does this distinction remain constitutionally necessary? And should, quote, absence from the Republic, unquote, be redefined, in your view?
Mr. Chairman, with technology now, absence, it has a different meaning now, because a case came before me as to the meaning of working from home, as to whether the president, this is my opinion, please, if the president should be out of the country, let's say for 1 day, and coming back, yes, the Constitution says there should be no vacuum. But if the person has, if the technology can make you work from outside your office, but well, the law says if you are out of the jurisdiction, fine. But if you are in contact with those who you work with, I don't really think, and the period is that short, maybe 1 day, I don't think there should be this ceremony when you are coming back the following day for somebody to swear an oath. And then the following morning, the president or whoever's oath is taken is back.
Is my law departing from the law? Is the law?
The law is the law, but I'm not departing from it. But what I'm saying, this is my personal position. Mr. Chairman, what I'm saying is that, let's say the president goes to Nigeria and will come back in the evening. He's not in the country, but that does not necessarily mean that the vice should take an oath to act for him when he's coming back in the evening. I mean,
so, my Lord, so you yourself, you are very dynamic in your views, because you see, earlier, your law is a law, which is true, but again, you have now qualified it, giving it a purposive interpretation to meet the times by saying that, yes, if the person is going out for just 24 hours, would there be the need to have that ceremony of having to take the oath and all? So, therefore, you would agree with me that eliminating the speaker's oath requirement in such circumstance would be prudent, correct?
No, Mr. Chairman, what I said was my opinion. That was my opinion.
You are here to express an opinion.
Yes, may not necessarily be the law. If the law insists that...
My Lord, is your opinion. My Lord, we would reserve that debate for another word. But
all right, thank you.
I will come back to you. Let the chairman intervene, and we'll go back to it.
Honourable members will listen to my Lord very well. He indicated that the law is a law. The thought-provoking issue that he is stating is that if the president is traveled to Nigeria and will come back the same day or the following day, both the president and the vice president are not there, do we have to do the ceremony by way of swearing in the speaker, only for him to return after the swearing in to come and take his position? So these are issues that we can look at. So he still believes that the law is the law.
So, well, Lord, I think the jury is out there to have their own bite, so I will not belabor. Now, there is clarity to me on the issue of, in the absence of the president, the vice president acts. There is also clarity to me on the issue of, in the absence of the vice president, the speaker acts. But what is not clear to me is the earlier position the speaker, the chief justice, would have to act and take the presidential oath. Now, my Lord, is this position you took earlier in response to a colleague's question emanating from the Constitution expressly, that in the absence of the speaker, the chief justice takes the oath of office as acting president? Is there such express constitutional provision? Or you are just, you stating so as a matter of course, that there should be no power vacuum? Because obviously, like it happened recently, it may happen again, where the president was out, my Excellency, Madam Vice President was on sick leave, and then Mr. Speaker was also out on official assignment, and for 48 hours, there was no head of state, technically, in the jurisdiction.
Mr. Chairman, I was answering a question asked by an honorable member as to the hierarchy. If the law says that for somebody to act as the president of the country, he must take an oath, that person has to take the oath.
My Lord, take it easy.
No, I'm fine.
No,
I'm fine.
you step by step.
I'm fine.
I mean, it's a good exercise that we have to embark on. If there is a lacuna in the Constitution, we must recognize it as a nation, and I believe the Constitutional Review Committee is following proceedings here. Now, my first question, and I will take it step by step. Is there an express constitutional provision that require the Chief Justice to take the presidential oath in the absence of the President, the Vice President, and the Speaker of Parliament? Is there an express constitutional provision?
Mr. Chairman, on top of my mind, I can't give any now. But if I'm given the chance, maybe I'll go through and see whether the Oaths Act or, I don't know, says so, or I don't know.
So let's do a little exercise. Granted, there is no such express provision. In your view, as a judge, and my Lord, it is your opinion that will add up to other views once you get to the bench. That court is a constitutional court. And if I may require, after losing the case, one of the panel members passed a comment that here we take policy decisions and look at the broader, affairs of the state. Just to assure me that don't be too heartbroken that you've lost this case. And it was a very sensitive matter that had to do with some freezing and of account and the state utilizing some exhibit account. And later I appreciated the position of the court that if all those monies that had been used by the state as exhibit account were to be said that go for your money, it would have been something else. So that is the background to the point I'm making. Now let's come back to the issue. In the event that the Constitution does not make an express provision, President, who?
You mean if the vice is not in?
Let me take it back.
Yes.
The president is not in the country. So traveled. Who is the next to take?
Mr. Chairman.
Is there an express provision?
You see, there shouldn't be a lacuna. At every point in time, somebody must head this nation. The three are not in the country. The next person is the Chief Justice. The next person, as we all know, is the Chief Justice. Even if there's no express provision stating that, there shouldn't be a lacuna, there shouldn't be a vacuum. And what I was saying, Mr. Chairman, is that if the president is just away, or those who are just away, or one of the three are I don't know. Mr. Chairman, I think...
my Lord, if you look at Article 60, if we run through Article 60, all through to 12, my Lord, I do not, my reading can never be accurate. I've read 60, the entire 60. There is no express provision for the Chief Justice to act in the absence of the Speaker. And my Lord, I am laboring on this point because recently it happened where Mr. President was out, VIP was not in town, Speaker himself was also out of town on official duties. And, so what is your view? I hope there's clarity now. Thank you very much.
It's clear. I think I think the Supreme Court that has the power to interpret can come out to say that, to make it definite that when those three people are not there, this person takes over, and this is
Which
what...
person? This person, Mr. Speaker, my Lord, this person.
When the president is not there, the vice takes over.
Yes.
When the vice is not there, is the speaker. And if the speaker is not there, I think there should be some express provision to say that there shouldn't be a vacuum.
So tell me your opinion. In your view,
my opinion,
who should be the next?
My opinion, the next should be the Chief Justice.
Very well.
That is my personal opinion.
I agree. No, my Lord, it's fair. Yeah. It's the personal opinions that become the law to guide us. I agree. Thank you very much. My Lord, I want us... Constitutional succession framework designed for unprecedented circumstances. In your view, should temporary successors beyond the vice president have full executive powers? And what constitutional limitations, in your view, should apply? Because they've taken an oath. They've taken the presidential oath.
Yeah, Mr. Chairman, yes, they've taken the presidential oath, but I don't think they can exercise all powers in the absence of the president. There must be a limit. For example, if the president should travel, the vice travels, and then the speaker takes an oath to act, and he decides to change ministers, appoint new ministers in the absence, it's not the best. So I think, yes, to avoid a vacuum, yes, somebody must lead. But certain decisions cannot be taken by that person. I think so.
But the person has taken a presidential oath.
Yes.
Now, how would you balance governmental continuity with democratic accountability in extended succession scenarios
I don't understand, please.
So we've talked about succession. They could be temporal. But we can have situations where the time could prolong. And in your view this afternoon, you have also said that, look, those powers must have limitations. For instance, the person acting should not have the power to fire or even appoint ministers. I've heard you. Now, I'm saying that in view of that, how do you balance this governmental continuity, which is allowing somebody to act, and the requirement of accountability?
Mr. Chairman, the state must run in the absence of those people, as we said earlier. Yes, we have to balance it. The state must not come to a standstill. The state must run.
My Lord. In your view, what are the specific constitutional amendments you recommend to modernize Ghana's political succession?
Can you please clarify the question for me?
Well, I'm read the temporal succession, who is taking over and all that, in the absence of this, that, and you've already expressed some broader views. Okay, so I now would want to hear your views regarding some recommendations, because you've talked about some limitations. I just need you, in view of that, to make certain proposed recommendations by way of constitutional review. Because you agree with me that even the inclusion of the Chief Justice in the succession plan, there shouldn't be vacuum. But there's no express provision. So share with us what this whole process, because it's very critical in view of the experience we've just had.
Mr. Chairman, I think this is for Parliament to do. You have to pass laws as to what should be done in those circumstances. I beg, sir.
My Lord, so you mean we should enact a law to regulate Article 60 further, but we can't enact where...
Or further, maybe when that issue comes before the Supreme Court, through the interpretation, the decision they will give, then they will clarify and give further instructions as to what should be done in those circumstances.
My Lord, you remember Article 1815, the Clomega? The Supreme Court left that bit to Parliament, and it is still hanging, where they said Parliament should enact to regulate 1815. Is it looking at? Supreme Court, in taking this up, would look at it holistically and provide a guide without saying Parliament should do this bit, because this is very constitutional, in my view. What do you think?
The duty of the Supreme Court, when it comes to interpretation, is the Supreme Court. So these are very good points you are raising. I think the Supreme Court, when the matter comes before them, will have to sort it out and give the various guidelines as to what should be done in the circumstances, Mr. Chairman. I think it's a gray area. So when it gets to the Supreme Court, then they will define.
My Lord, the records have it that you've been at the Court of Appeal. Okay. And you presided over that.
Mr. Chairman, you know that commission's name. Dzamefe Commission, the commission. Committee, sir, it's a commission.
Yes, yes, yes.
Thank you, sir.
Lord, you know, when I forget, assist me.
Thank you.
Lord, so in that commission that you chaired, what did you really unearth by way of the whole hearing? And do you think that the recommendations that came there too has been implemented to guide football administration in our country?
Mr. Chairman, somewhere we said, one, players should not be paid cash. We all saw what happened in Brazil when we had to fly money to Brazil for players, and we saw some people holding theirs. It was one bad thing for Ghana. Then number two, we also recommended that the state should not sponsor support, because we were thinking that instead of flying people from Ghana and booking hotels and feeding them, why don't we buy tickets for Ghanaians who are in that country? Then again, we also recommended that every time the Black Star plays, at least 3 local players should be in the team for continuity, 3 local players. And you all saw the House of Oak goalkeeper, the local player who did very well in the post, conceding no goals. These are some of the recommendations we made. And then that we also recommended that the state, the parliament should know all matches to be played in the year ahead of time. I think sometimes the organizers wait when it's a week or 2 days to the match, then they bring the, if FIFA fix a match, you can never change it. You are forced to find money. So we recommended that matches should be, the state should know far ahead of time so that they can prepare towards those matches, not to wait till 2 days and then they bring you a budget. You have to, by all means, find money and send the players. These are some of the recommendations we made.
My Lord, this is a good point to ask my very last question to end the day.
Thank you very much.
To end the day with you. My Lord, you dealt with criminal cases in our criminal jurisprudence where lawyers and judges came to a certain conclusion that there was this non-bailable, a groundbreaking or a landmark decision that bail cannot be used as punishment. Bail. What I want us to do to conclude the day is inquiry bail and is unable to complete investigations and is not ready for court would grant bail on certain terms. Now, for all your years as a judge, would you suggest, would you say that an institution like IOCO, OSP, or the police service itself should arrogate to itself the power to demand what has become known as justification as bail condition, especially when they are not even ready to come to court? My Lord, I'll give you a bit background to it. In the public space, what we have heard through public statement issued, Chair, I just want to give my Lord in our country so that he can appreciate it. My Lord.
But my brother, you know the rules, that when you are given the opportunity to ask questions, our rules does not allow you to address. The rules does not allow you to share your opinion or argue. That is why I am just reminding you of our rules that
I'm guided. So, Honorable Nominee, I am giving you this background in view of the fact that in recent times, Iyoko specifically, they have justified their action with valuation report as the basis for their bail condition because of the amount they are investigating. Because of the amount they are investigating. As a judge, don't you think that these considerations are matters for the court to determine? And that to the extent that the investigative body, like Iyoko, is not done with its investigation to bring the person to court, demanding landed property as a condition amount would be...
From my experience, when we are faced with granting bail, we look at the charge, the amount involved, if it's liquidated, if it's money, the amount involved, and weigh the pros and cons as to whether the person will consider not coming to court for trial, whether the person is a flight risk, and we consider all that. You can't be, the basis of bail is to make sure that the person comes to face trial. But then, you can't be investigating a case, let's say, for example, $1 million in a theft case or something, and grant bail 10,000 cedis. There's a possibility that you are indirectly telling the person, go away. So we consider all these things. But I cannot tell what informed that decision by Iyoko. No, I cannot tell.
The government...
I cannot fault them for that.
My Lord, I'm not saying fault them. Yeah, my Lord, I'm not saying fault them. My Lord, I'm not saying fault them. On the issue of courts, I have no problem. Because you, the presiding judge, will now look at the charge sheets, the evidence available, and in fact, in our modern criminal trial system, you even make available all your documents you are relying on as part of the discoveries, contrary to the previous practice where you keep it under your armpit and be releasing them one by one. Now, from day one, you are to give every document to your adversary or to the accused. I am concerned about the use of such powers at the investigation level, where you have not even concluded, but you know that the amount you are investigating is X. A view on for us, not to blame Iyoko. That's not what I'm asking you to do. We are expressing a view to enrich democracy.
Mr. Chairman, at the investigative level, they are not saying you are guilty or not guilty. Granting bail and putting any figure on it is just to make sure you are available. And Mr. Chairman, don't forget that when you get to court, there's the possibility of the court varying even your bail bond, lower or even higher. So it's just a means of making sure that you attend, so you report yourself for the investigation. That's all. That's all about it, sir.
Yeah, thank you very much, my Lord. We have come to an end of the vetting. Permit me to recognize our revered justices of the Supreme Court seated behind you. Then I will come to the family members. First on the list is His Lordship, Justice Paul Bafoboni, Acting Chief Justice. You are welcome. His Lordship, Justice Isifu Imoro Tanko Amadu, Justice of the Supreme Court. His Lordship, Justice Henry Anthony Kofi, Justice of the Supreme Court and President of Association of Magistrates and Judges of Ghana. His Lordship, Justice Richard Ajay Frimpong, Justice of the Supreme Court of Ghana. May I, on behalf of the committee, welcome my lords in our midst. I then proceed to acknowledge the presence of Mrs. Antoinette Dzamefe, the wife of the nominee, Mr. William Krakani, Dr. Kofi Dako Anoche, Togbi Honuafe, Chief Honufe, Chief of Lume, Togbi Haji Sulfada Lume, Togbi Apana Dzamefe Lume, Togbi Hlomachi Lume, Mr. Maoli Dzamefe, Mr. Dan Jide, Dr. Maoli Ajore Adjoe, Director General TVET Ghana. We also have Tetefio, Mr. Benji Halm, Chairman, Premier Keep Fit Club, Tema. Mr. Do, Patron, Premier Keep Fit Club, Tema. Mr. Ken Thompson, former MD, Dalex Finance. Mr. Eyome Aka, Mrs. Mawena Aka, Mr. Bonnie Lawekpo, former headmaster Medas Tema, and Mr. Danny Moore. You are all welcome. Honorable nominee, we thank you very much for attending upon the committee and providing answers to numerous questions posed to you. You are hereby discharged. You will surely hear from the committee. Thank you very much for coming.
Thank you, Mr. Chairman and honorable members.
Honorable members and our guests, it's time for lunch. You are invited to join us, take lunch together. We are resuming exactly at 3 o'clock to take the next nominee. Thank you very much.